This is Kyle Munson, the Iowa columnist for the Des Moines Register, and I'm here with Daniel Zimmerman this morning in his greenhouse in Mitchell County. And he's just gotten the call about the Iowa Supreme Court case. Daniel, how did it go this morning?
Well, I guess if you look at it from our side, it would be a good morning.
Yeah. So, I mean, this was the case where your son, Matthew, was ticketed for driving a steel-wheel tractor on a hard surface road here in Mitchell County. And then it worked its way through the courts because it became a religious freedom issue, right? I mean, you felt strongly that this was the county infringing on your freedom, and so the 7 Supreme Court justices of Iowa unanimously ruled in your favor.
Yeah, that is correct. It was my son, and yes, it's too bad that things couldn't have been worked out at the table the way I thought they should have been worked out, or how I know we're all supposed to work things out. I guess I still have a concern about the other side, that this isn't just us and them. I still see it as there has to be a way to get along with everybody, and I guess that's I don't know the answer to that yet. I would still think there's enough of human being in everybody to understand our differences of opinion and still do what's right.
Obviously, we're disappointed with the decision. We thought the statute was constitutional, but just reading over the decision, even though it's a reversal, it's not truly disappointing to Mitchell County. The Supreme Court did find that the statute was facially neutral. They found that Mitchell County is not intentionally discriminating against the Mennonite community. The one issue that they reversed on was a very limited issue. They said that Mitchell County did not use the least restrictive means possible to enforce the ordinance. The supervisors had discussed that very issue back in 2010. So the ordinance that was reversed here is not the ordinance that's now in effect. All this does is reverse Mr. Zimmerman's fine, and that was $10. In 2010, Mitchell County enacted a new ordinance. The Supreme Court reversed on a very limited issue, which was we did not use the least restrictive means. In other words, they said it's possible that a tractor could be driven on the roads without damaging the roads, and our ordinance was a flat constitutional ban on all steel wheel traffic. The new ordinance is less restrictive. In other words, it says you can drive a tractor on Mitchell County roads with steel wheels, but if you cause damage, then that's a violation of the ordinance. So we believe, while the ruling reverses Mr. Zimmerman's we believe the ruling reverses Mr. Zimmerman's conviction. The new ordinance that we adopted in 2010 is addressed by this decision, and in fact we think that this decision in and itself would uphold the new ordinance. So it's disappointing we didn't win here, because we're going to have to go through all the steps. We're going to be back in the Supreme Court 2 or 3 years from now, unless the Board of Supervisors decides to appeal this to the United States Supreme Court. We haven't had a chance to discuss that yet, but it's certainly a possibility. I've been in contact already this morning with the Nymaster firm out of Des Moines to discuss a possible appeal to the United States Supreme Court. So